everyone, and welcome back. This is S.C. Coleman, author, and today in this video we're going to continue in one element of the past video, and that is in reference to the Wackenhut Corporation, which I did a section on my last video, or at least I believe my second to last video, in reference to a particular CIA document and its relation to the Wackenhut Corporation. Now, this is going to delve a little bit into the subject of subcontracted security guards actually operating as the so-called law enforcement. But another way to think about it would be security forces, as we're most familiar with in, say, Africa or the Middle East. Either way, it's the concept of a force mechanism, and most of this is based off of not necessarily the tangible operational capability with an expectation of meeting combat, but rather the appearance of that. And so people go along with something out of the appearance of force rather than the actual leveraging of it. And that's the reason why you see entities like so-called sheriffs, highway patrol, police, and TSA agents, which aren't really agents, but individuals like that. They wear body armor and no helmets. It's because the body armor, just like the phony YouTube gunners, or there's some stupid word for it, but you know, they will wear body armor that very clearly does not contain sappy plates or some other type of actual protective mechanism, and therefore it is purely for a visible image related purpose. And this is the documentation I've got for this particular video, starting with Private Security Officer Selection and Training Guideline, copyright 2004 by ASIS International, ISBN, which stands for, I believe, International Standard Book Number. I have many of those on my own. They're automatically given when you self-publish on any website. Printed in the United States of America. Commission members. Now, as you can see, I have highlighted a few, and those are the interesting names I'm going to list off specifically. We have Chad Callahan, CPP Marriott International Incorporated, and a Pamela A. Collins, ED.D, CFE, Eastern Kentucky University. And Pamela Collins is also listed under review committee members, this first section being the commission members. Then you have L.E. Mattis, that's M-A-T-T-I-C-E, or Matisse, Boston Scientific Corporation, Basil, J. Steele, CPP, Sandia National Laboratories, Don W. Walker, CPP, Securitas Security Services USA Incorporated. And now under review committee members, we have Mark H. Beaudry, CPP, IBM, Pamela A. Collins, again from Eastern Kentucky University, Sandra M. Cooey, CPP Principal Financial Group, Court L. Dixon, Kraft Foods, David L. Foley, Security Forces, /SFI Electronics, Michael E. Goodboe, ED, the Wackenhut Corporation, Bernard D. Greenwald, Securitas, Steve Hess, Government of British Columbia. That's a fun one. Richard H. McClintock, Dartmouth Hitchcock Medical Center, Bonnie S. Michaelman, CPP Massachusetts General Hospital, Kelvin MNG, CPP, Yaletown Technology Group Incorporated, Catherine E. Scarborough, Eastern Kentucky University, and David G. Schott, Kennedy Center for the Performing Arts. Those are, of course, names that you want to see on regulatory guidelines for security forces. Threat, an indication of something impending that can result in damage or injury. Well, that's not the definition of threat that I'm familiar with, but of course that is the definition of threat that they would want in reference to this force mechanism or private army, if you will, that they're attempting to build under the auspices, meaning the office or name of law enforcement. Regulation of private security. Private security officers selection and training criteria vary from state to state, ranging from comprehensive training requirements for every private security officer to little or no training at all. That's just, of course, to say that they don't control every aspect. That's what that means. One of the main goals of the private security officer selection and training guideline is to develop and encourage adoption of minimum national criteria for the selection and training of all private security officers, be they proprietary or contract. And I bet that this stuff is being written outside of the country, most likely in Europe, like Belgium. The development of such a minimum criteria has become essential for enabling the private security industry to meet the need of providing effective security to its clients, as well as meeting the demands associated with new homeland security initiatives. It's your auspice for a private army to be leveraged by foreign enemies against the people that live here. Effective security today requires workers who are familiar with all aspects of a facility's security system for assessing and containing potential threats. Security officers are required to be well versed in emergency procedures and able to work with an organization to ensure that emergency procedures can be implemented successfully. They are also required to be able to work closely and effectively with public safety personnel. Of course, they're also staffing the public safety personnel, quote unquote. The ability of U.S. companies to protect the nation's critical infrastructure and contribute to homeland security efforts, so control, or else, depends largely on the competence of private security officers. Therefore, private security officers and applicants for private security officer positions should be thoroughly screened and trained in accordance with these recommended criteria at a minimum. The following tables prescribe the necessary steps to be taken by regulatory bodies and companies in the U.S. towards the development of such guidelines, beginning with effective licensing and enforcement. Recognizing that specific details of each regulating body's licensing laws are different, elements listed in Table 1 State Regulation of Private Security are nevertheless basic for effective private security officer legislation, and blah blah blah. So as we will notice, this manual or so-called guideline is implemented by everyone in every capacity as far as all of the phony state, corporation, government, acting under the color of law enforcement components. And we will find elements contained in here that we will find replicated in the next subsequent paperwork. A regulatory body within the framework of a state agency is listed here. Now, the wording there is really important. Within the framework of a state agency. To me, that sounds like they're inputting it into the quote-unquote framework of a state agency, not necessarily that it is that state agency. Just that it's within the framework of the state agency. A minimum of a $1 million liability insurance policy, and it states here specifically minimum of 1,000,000,000 per occurrence. And we'll find that exact copy and paste wording replicated in subsequent documentation. Private security officer registration licenses, as said, a registration and licensure of all. As we know, that's a main component by enemy agents to leverage control over and against the population for maintaining control. It states that a candidate must be a citizen or national. So here they're stipulating between a citizen and national, as in they're different things, of the United States, or an alien authorized to work. That's a big one there. Now, as I've specified before in previous videos, the evidence is there to state that they have the capability to blacklist your social security number. If you step out of line or do anything they don't like, then they will ensure that you can never get hired, because all hiring processes are on a social security number. You will never be able to purchase a firearm because all firearm background checks run a social security number. You'll never be able to get benefits from so-called benefits of them taking money and then doling it out with strings attached. One of those strings attached is that you're supposed to adhere to what they want, regardless of what the Constitution or anyone else says. And if you don't, then they'll blacklist your social security number, thus ensuring that whenever you apply for it, you'll have paperwork that doesn't get filed, you'll have things lost, and so on and so forth. And now we have practical evidence that shows this. Social security number screening. Establishing a process of verification of an applicant's name and social security number. Additionally, consideration may be given to conducting a social security number trace to determine if the number has been actively issued, is not retired, and also to obtain an address history. The address history should be compared against addresses given on the application and should be used to verify criminal record checks have been conducted in all required residence addresses. See Appendix A for adjudication scoring considerations for Social Security number trace. Of course, this just means that anyone at all behind the scenes, for any reason whatsoever, can invalidate your Social Security number, thus rendering it almost impossible for you to live in this mechanized controlled system used specifically for enslaving the local population for foreign interests. Now, the registration, license, and certifications. Establishing a process for verification of the subject provided license, registration, credential, or certification information against the appropriate agency. Compare given information on a licensee's name and address, licensing board or agency name, license type, license number, status, and original issue date if provided by the agency. Note any negative license actions or sanctions. And here down at the bottom it's got a footnote. For any private security officer with driving responsibility in a motorized vehicle, not limited to those driving company vehicles, consideration should be given to conducting an annual motor vehicle registration check, also known as an MVR DMV check, to verify such things as license information, type, class of driver's license, full name and address at the time of last license renewal, restrictions or violations, convictions, and license revocations, automobile insurance cancellations, and accidents. So this guideline we will find replicated, but to begin with, before we get into how this guideline sheet is being implemented as law, written by this unelected committee individual, without regard for the general population and what they think, we will look at G4S Secure Systems, which is another name for the Wackenhut or Wackenhut, however you want to say it, corporation. Now, during the last decade, according to this, four-stranded helical structures called g-quadruplex, or G4, have emerged from being a structural curiosity observed in vitro to being recognized as a possible nucleic acid-based mechanism for regulating multiple biological processes in vivo. The sequencing of many genomes has revealed that they are rich in sequent motifs that have the potential to form g-quadruplexes and that their location is not random, correlating with functionally important genomic regions. In this short review, we summarize recent evidence for the in vivo presence and function of DNA and RNA, G, quadruplexes, and blah, blah, blah. So this right here is a short, essentially overly worded definition of the G quadruplexes, which is listed as G4. Which takes us to G4S Electronic Monitoring. Mark Griffiths, Director of Business Development, G4S Justice Services Incorporated, May 2009. This is a PowerPoint. G4S Care and Justice Services. Electronic monitoring of offenders, prisons and offender management, prisoner transportation and court services, children's secure training centers, and residential facilities. What does that sound like? Immigration detention centers, immigration transportation, immigration case management and supervision, police custody and support services. G4S electronic monitoring includes RF tagging. RF stands for radio frequency, tracking, other emerging technologies, alcohol, drugs, and case management. Now, as far as the electronic monitoring technologies, I have highlighted here in the middle G4S RF tagging, RF patrol, monitors home curfew against agreed schedules, variable range, and the big one here, GPRS, GSM communication to report multiple alarm types. That means this company and all associated with can be tried for treason and is specifically under the context of espionage, for one, spying. This is a major breach for the interest of the country and the people. It is essentially speaking what the National Security Agency does and what the various components in the military do in relation to essentially snooping on text messages, phone calls, all that type of stuff, right? The radio frequency spectrum range, which also includes radiation mapping and things like that. That is something that normally you would have to have FISA warrants for. You would need to have, there's a whole bunch of red tape and things to make sure that you're not abusing that. And these individuals, these mostly in many cases foreign security firms, can do it at will. And then also it lists secure strap with embedded fiber optic cord and mobile monitoring unit drive-by available. G4S electronic monitoring technologies, and here's a big one. G4S satellite tracking. I'm familiar, relatively speaking, with satellites, and I know they're kind of crap. But either way, satellites determine position, GPRS, GSM communication to report multiple alarm types as listed again. Normally used to monitor movements retrospectively, but can be used to monitor inclusion and exclusion zones in real time. Requires daily recharging. Can be used in conjunction with a separate home unit for RF only while at home. G4S prison area monitoring. 2-second location updates, receivers and exiters installed throughout prison. Historical and real-time data. Presence monitoring and doorway triggers. Inmates secure ankle-worn device. Officers have belt-worn devices. Improves prison safety and efficiency. And then finally we have G4S EM operations worldwide. Lists the USA as RF voice, alcohol, and GPS tracking, case management, range monitoring services. England and Wales, RF and voice, full monitoring services, largest in the world. Northern Ireland, RF, full monitoring services. Israel, 1,000 RF full monitoring services, Ministry of Interior. New Zealand, RF for community detention court sentences, some monitoring devices. Australia, Department of Correctional Services. Austria, RF pilot, Ministry of Justice. And the Netherlands, tracking pilots, Ministry of Justice. 350 RF including monitoring services. So for anyone who's even remotely familiar with any semblance of law and order, of what a FISA warrant is and some of these other things, which mostly are in fact illegitimate and unlawful, either way, this is a private entity acting globally, the globalist, if you will. It is a mechanism based off of, in its name, a regulatory structure for DNA sequencing. Now, this is a professional services agreement, involuntary commitment transport, North Carolina, Wake County. This agreement made and entered into this first day of July 2018 by and between G4S Secure Solutions USA Incorporated, a Florida corporation having a place of business at 9000 Ariel Center Parkway, Suite 105, Morrisville, North Carolina. Party of the first part, hereinafter referred to as the provider, and the Sheriff of Wake County with offices at Public Safety Center, blah, 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 Raleigh, North Carolina. And of course, G4S Secure Solutions has many addresses, all of which are likely not even real. Services to be provided. The sheriff is in official capacity as Sheriff of Wake County, hereby grants the provider for the term of this contract unless earlier terminated the exclusive right to provide the services described in Schedule A, attached hereto and incorporated hereinafter, blah, 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 in reference to a RFP or request for proposal. Access to records. Provider agrees to retain at its office accurate books, records, or other documents relevant to determine provider's performance under the agreement. Such books, records, and other documents shall be retained by the provider at its office for a period of 36 months after the close of the county fiscal year, and available to the sheriff or his designee for inspection during business hours upon reasonable notice at no additional charge. And blah, blah, blah. Insurance. Liability. 1000 or comma 000, each accident, disease, each employee deceased policy limit with no limits less than 1 million per occurrence. And if you want to say it, copy and paste, no less than 1 comma 000 comma 000 per occurrence. It's not written out million, it's written out in 1 and 0. That's a copy and pasted section from the manual guideline that we read before. Scope of work. Upon request by sheriff in accordance with Section 4 of the schedule, provided through its patient support staff, shall provide transportation in accordance with providers' post orders for individuals, individual, and collectively individuals who have presented to sheriff seeking transportation for involuntary, right? Let's read this for a minute. Presented to sheriff seeking transportation for involuntary committed patient transportation. So this individual is being presented to the sheriff against their will for transportation, and they're being listed as a patient. Yeah. That is written exactly like that. The patient support staff shall transport all the necessary paperwork that is required by the sheriff and the hospital or facility, such as a detention facility, aka a jail or a prison or whatever, to which the individual is transferred. Facility is defined in blah, blah, blah. And then this has the work schedule, the shifts, and call center. Patient support staff shall wear uniforms agreed upon by the parties and compliant. Patient support staff shall at all times wear shirts with provider's logo on them and a picture ID that clearly indicates they're employees of provider. Patient support staff shall transport individuals in a Dodge Charger, individually a vehicle and collectively the vehicles, which is owned by sheriff. Sheriff shall lease provider the number of vehicles agreed to in writing by the parties pursuant to blah, blah, blah. Vehicles shall have clear polished plexiglass barrier between the front and rear seats. Vehicles shall have the G4S logo clearly displayed on the vehicles. Sheriff shall in no event provide less than 2 vehicles at all times during the period this contract is in force. Blah, 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 blah. Launch station and hub. Priority. And then this is signed leaseor, Sheriff of Wake County, Donnie Harrison, official capacity, and Michael Fulks as. Now here's a big thing. Michael Fulks, well, Fulks, but that is going to pop up later, and these are signed in 2018. So you read that right. The sheriff enforcement are subcontracted security guards, and we will find it gets quite a lot worse. Indianapolis Security Contractors Agreement between Allied Universal Security Services, G4S Secure Solutions USA Incorporated, and Securitas Security Services USA Incorporated, and Service Employees International Union Local 1, September 1st, 2019 to August 31st, 2023. Now, this stipulates in the preamble that they will endeavor to treat each other with dignity and respect. Not shall, but will endeavor to. That's obviously non-binding in any form. And also that the single greatest threat to continued success is the proliferation of non-union competition in the security industry. That's exactly what that sounds like. And this is with this particular documents with the city of Indianapolis. And of the work listings, work sites, we have transit systems, all work on or about airports, higher education, and healthcare facilities. Those are the big ones. Now, under immigration, in the event an issue arises relating to Social Security number, referencing, of course, that guide we just read, that they need to provide a union with a copy of any correspondence or notice about work authorization status of an employee. And then any lawful corrections in an employee's documentation name or Social Security number shall not be cause for adverse action. It's interesting that's stipulated in this contract. And then subcontracting, and the contractor or the entities listed here shall have the right to subcontract work. So, as usual, you have multiple layers where you've got one contract and then you got another subcontract and another subcontract, and eventually the web is impossible to find the original source, and that, of course, is the intention there. And now referencing one of those names there, Securitas. The Securitas cipher machine, an application for a patent filed in Germany 23 February 1918 by Gewerkschaft Securitas of Berlin, one of the companies later associated with the development of the Enigma. Inventor's name does not appear in the patent papers, blah, blah, blah. The machine isn't so much important, but I'll read the description here. An electromechanical cipher machine in which the circuit paths between a keyboard and a bank of incandescent lamps are irregularly permuted by means of an intermediate rotor maze. And the operative word there, of course, being maze. Security Services Agreement between the Chicago Housing Authority, CHA, and Securitas Security Services USA Incorporated. Now, the address here is very important because it lists a 9-campus drive, Parsippany, New Jersey. So that's a university address. What a surprise. And then the Chicago Housing Authority is a municipal corporation. This is dated September 17th, 2022. It is for the providing, development, and operation of housing for low-income families. I think we all know what that means. And here's a really interesting section, confidentiality. The contractor agrees that the CHA information and all information, documents, records, reports, and materials in any form prepared or assembled or received by the contractor or provided to the CHA under this agreement, collectively the confidential information, are to remain confidential and to be used solely for the purposes of meeting the objectives of this agreement. The contractor agrees that the confidential information and its existence shall not be disclosed or made available to any individual organization other than the CHA, HUD, or courts of competent jurisdiction or administrative agencies pursuant to a subpoena without the prior written approval of the CHA. In the event disclosure is required by court or administrative agency pursuant to such a subpoena, the contractor shall notify the CHA immediately of such requirement and the circumstances regarding the same, and shall provide reasonable assistance and cooperation at the CHA's reasonable expense to enable CHA to seek a protective order or otherwise prevent such disclosure. Boy, what are they hiding? Notwithstanding the foregoing, the contractor shall not be obligated to withhold such disclosure beyond the time ordered by such court or administrative agency pursuant to such subpoena, unless such subpoena is quashed or the time to disclose is otherwise extended. Upon the expiration or termination of this agreement for any reason, the contractor shall return, or if requested in writing by the CHA, destroy the confidential information of such proportions thereof which the CHA has requested the contractor to destroy, and all copies thereof, and certify to the CHA in writing, CHA, that it no longer has in its possession or under its control such confidential information in any form whatsoever. The contractor agrees that irreparable injury may result to the CHA if this section is breached, and the contractor or any of its employees accordingly, in addition to any and all other remedies to which the CHA may be entitled. The CHA shall also have the right to obtain equitable relief, including but not limited to injunctive relief, to prevent the disclosure of the confidential information, plus reasonable attorney's fees and other litigation expenses incurred in connection therewith, without having to post any bond or other security or prove actual damages. The right to equitable relief in this paragraph shall be in addition to and may be sought notwithstanding the dispute resolution procedures found in Article 5. And then patents and copyrights. To the extent applicable, the CHA reserves an exclusive, perpetual, and irrevocable license to reproduce, publish, or otherwise use, and to authorize users to use for CHA or HUD purposes, including but not limited to commercial exploitation, a copyright or patent in any work developed or discovered in the performance of the services under this agreement, and any rights or copyright or patent of which the contractor purchases ownership or obtains a license with funds awarded pursuant to this agreement for the purpose of meeting the objectives of the agreement. And in the event of conflict between the terms and conditions of the general conditions and terms and conditions of the agreement, the terms and conditions of the agreement shall control. That's interesting. Contractor's equipment and property. Any equipment /software provided by the contractor and information gathered therewith in connection with the contractor's services is for contractor's use and will always be contractor property. Contractor is not selling or leasing any of the equipment software to CHA, and contractor will remove its equipment /software upon termination of the agreement. Sounds like they don't want to leave any trace. I wonder why. Insurance. Prior to the commencement of this agreement, contractor agrees to procure and maintain at all times during the term of this agreement the types of insurance specified below in order to protect the Chicago Housing Authority, its respective commissioners, board members, officers, directors, agents, property management firms, construction management firms, employees, vendors, invitees, and visitors against bodily injury or property damage, claims which may arise from or in connection with services performed under this agreement, and from the negligent acts, omissions, and errors of the contractor, its officers, directors, officials, subcontractors, joint venture partners, agents, or employees. The insurance carrier used must be authorized to conduct business in the state of Illinois and have an AM Best rating of not less than A-V2. General liability not less than, again, 1,000,000 per occurrence. Workers' compensation and employers' liability. Coverage must be in accordance with the laws of the state of Illinois and endorsed with a waiver of subrogation in favor of Chicago Housing Authority. Contractors shall submit a certificate of insurance via an email to the CHA procurement specialist. Additional insurers, collectively referred to as the additional insureds, shall include Chicago Housing Authority, Chicago Housing Administration, LLC, and or other limited liability company as established by CHA, its respective commissioners, board members, officers, blah, blah, blah. Well, that is clearly suspicious and most certainly criminal. Indemnification. The contractor agrees to protect, defend, indemnify, keep safe, and hold the CHA, its officers, officials, employees, and agents, and contractors free and harmless from and against any and all liabilities, losses, penalties, damages, settlements, environmental liability, costs, charges, professional fees, or other expenses or liabilities of every kind, nature, and character, including those related to personal injury, death, damage to property, defects in material or workmanship, actual or alleged infringement of any patent, trademark, copyright, or any other tangible or intangible personal or property right, or any actual or alleged violation of any applicable statute, ordinance, order, rule, or regulation, or decree of any court, arising out of or relating to, and all claims, losses, liens, demands, obligations, actions, suits, judgments, or settlements, proceedings, or causes of action of every kind, nature, and character, collectively claims, in connection with or arising directly or indirectly out of this agreement and or the acts and omissions of the contractor or any of the employees, including but not limited to the enforcement of this indemnification provision, to the extent any such claim is caused by the negligence, gross negligence, willful misconduct, or other fault of the contractor. The CHA shall have the right at its option to participate in the defense of any suit without relieving the contractor of any of its obligations under this section. The contractor expressly understands and agrees that requirements set forth in this indemnity to protect, defend, indemnify, keep safe, and hold the CHA free and harmless are separate from and not limited to the contractor's responsibility to obtain, procure, and maintain insurance pursuant to any other section of the agreement. Furthermore, the indemnities contained in this section shall survive the expiration or termination of this agreement for any reason. Electronic or DocuSign by Sheila Johnson, Deputy Chief Procurement Officer, and that's, I'm sure, not a real person, and LaRue Little, weird name, DocuSign, Deputy Chief Legal Officer. And then on the other side, Securitas Security Services USA Incorporated, Sean Keating, Area Vice President. And the damning paperwork continues. Agreement to defend, indemnify, and hold harmless the university. Oh, this sounds familiar. The university requires the successful contractor, in addition to the certifications regarding accessibility standards above, to agree to defend, indemnify, and hold harmless the university, its officers, directors, successors, employees, and agents against any and all third-party claims, liabilities, obligations, judgments, causes of action, costs of expenses, including reasonable attorney fees, claims against the university to the extent such claims are based on allegations that the product or service is not compliant with the accessibility standards. Contractor agrees to defend, indemnify, and hold harmless the university, its officers, directors, successors, employees, and agents against any and all third-party claims, liabilities, obligations, judgment, causes of action, costs, and expenses, including reasonable attorney fees, claims against the client university to the extent such claims are based on allegations that a product or service is not compliant with the acts, and WCAB, bunch of other nonsense. General, commercial, general liability coverage. It says general twice. General, commercial, general liability coverage lists here $2 million for each person, $2 million aggregate for under bodily injury, $5,000 medical each person, property damage $2 million each accident, blah blah blah. Proof of insurance shall name the Board of Governors of Missouri State University, its officers and employees as additional named insureds. Shocker. Affidavit for Anti-Discrimination Against Israel Act. Alright, so let's pause there. You have universities today, all of them, protesting Israeli occupation of Palestine. So, quote unquote, Palestinian rights and all that. Meanwhile, for their security forces, they have an affidavit of anti-discrimination against Israel. Well, the act anyway. And this document stipulates the contractor certifies that the company is not currently engaged in and shall not be for the duration of the contract engaged in a boycott of goods or services from the state of Israel. Companies doing business in or with Israel or authorized by, licensed by, or organized under laws of the state of Israel. It's really weird that it's listing out the state of Israel, like it's a state of the United States, like the state of Georgia, or here, the state of Missouri. As you can see here, it lists out capital S, state of Israel, or persons or entities doing business in the state of Israel. So it must be a component of the United States then, right? And then we have a memorandum of understanding and agreement by and between State Center and Community College District, Peace Officers Association, temporary contract with Security Service West Fresno, and First Responders Campuses. That's a weird name. First Responders Campuses. Currently building the First Responders Campuses, and this agreement is for when they will no longer provide construction security. District is in need of security for 2 campuses. Signed Juliana D. Mosier, Vice Chancellor of Human Resources, and that signature looks like garbage and unlikely to be a real person. Same with Robert Kiffer, and this is dated the 23rd day of May in the year 2023. Next, we go to the state contract number blah 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 for security guard services, State of Florida Department of Management Services, with Universal Protection Service LLC, doing business as Allied Universal Security Services LLC. Term will be a minimum of 5 years. Term shall expire on March 3rd, 2020, but it can be renewed at any time for any duration, etc. It's docu-signed, again, by a Tammy Filia, Chief of Staff for State of Florida, and this is dated for March 2020. Now, in the contract, it lists something called an emergency response security guards. These are licensed security guards, either armed or unarmed, who provide services when an executive order has been issued by a government entity. An unarmed emergency response security guard shall have a Florida Department of Agriculture and Consumer Services Class D security guard license. An armed emergency response security guard shall have a Florida Department of Agriculture and Consumer Services Class D security guard license and Class G statewide firearms license. Contractors shall be required to provide emergency response security guards as specified by the executive order and or at the customer's request. Emergency response security guards must have training in first response and may be required to work irregular hours, work more than 8 hours per day, work extended periods including weekends and holidays, work at locations other than their official headquarters, and or work in adverse conditions. Travel expenses for the emergency response security guards shall be on a cost reimbursement basis, blah, blah, blah. So this, of course, ties in with their planned disaster element for establishing a firm control, unlawfully, of course, and their operational word here, of course, are emergency response security guards. It's pretty obvious what they're attempting to do here and under which kind of cover. Now we have approval for contract for security services. Bloomington campus, we find the universities, as usual, are heavily involved, if not the operational component that's actually producing this sort of treason. The Ivy Tech Community College Bloomington campus, Universal Protection Services LLP, that's limited partnership, doing business as Allied Universal Security Services. This is a 2-year agreement worth $300,519 with a total amount of $6,000, or each year is $3,000, so total amount is $601,039. With the State Board of Trustees, and the State Board of Trustees must approve any contract imposing a financial obligation on the part of the college exceeding $500. That's interesting. The State Board of Trustees hereby approves the college entering into a contract with the Universal Protection Service, LP, doing business at Allied Security Service, Universal Security Services. This is signed Andrew Wilson, Chair, and Michael Dora, Secretary, dated February 6, 2025. Now we have Small Business Reserve SBR request for proposal for security guard services, June 11, 2021. This is the Department of Procurement and Strategic Sourcing, University of Maryland, Baltimore County, Baltimore, Maryland. Performance deficiencies. If the contractor fails to perform, they gain a $100 fine. Oh, that's big deal there. Wow. Scary. Lateness or failure of guard to arrive for duty on designated time, or failure to call in within the first 15 minutes of shift, $25, blah, blah, blah. Allowing a guard to work is not wearing prescribed uniform in a clean and neat order, failure to maintain equipment, allowing a guard to work who is both physically and mentally incapable. And of course, as we see, these fines mean nothing. $50, $100, $25, it's not a big deal. And if the company's doing it, well, they can order a contractor to do something against these regulations, and the company will just pay the fine. Unauthorized or misuse of telephones. Telephones are for business or emergency use only. A violation will result in the contractor being billed for telephone charges. Wow, isn't that interesting? That's called nickel and diming. Clearly, they absolutely despise the people. They don't care about these quote-unquote security guards. They are fodder, right? Every police, sheriff, highway patrol, immigration, all of the other things listed here, TSA, whatever, they're all fodder. They're absolutely meaningless to the people that are hiring them. Their entire purpose is to belligerently occupy the land, to harass the population, and then to take the fall for what they've been ordered to do. This also stipulates unauthorized reading of literature or material not connected with the job, or listening to a radio or watching television unless authorized by blah, blah, blah. Congregating with other security personnel at any post unless performing assigned duties. Wow, that really sounds like they trust these people. conduct unbecoming a guard or prejudicial to the standards of the security industry. UMBC's rights or remedies shall not be limited in the event UMBC's actual damages exceed the amount withheld from billing, or in the event UMBC fails to require performance of any term or provision of the contract. And there, once again, we find their most important control mechanism, as usual, to be financial. They would prefer to avoid getting their hands dirty. And interestingly, we have the section payments to contractors by electronic funds transfer. If the annual dollar value of this contract will exceed $200,000, the proposer is hereby advised that electronic funds transfer (EFT) will be used by the state to pay the contractor for this contract and any other state payments due contractor unless the state comptroller's office grants the contractor an exemption. By submitting a response to this solicitation, the proposer agrees to accept payments from EFT. The selected proposer shall register using form COT-GAD X10 Vendor Electronic Funds EFT Registration Request Form. Wow, say that 10 times fast. Blah, blah, blah. Minority Business Enterprise Notice. So this is going to be DEI. An MBE goal is not established for this procurement. However, state-certified minority business enterprises, MBE, are strongly encouraged to respond to this solicitation. Minority participation is very important to UMBC in the state of Maryland. Yeah, what a crop. Now this brings us to the State of West Virginia delivery order date September 28, 2021, security services for campus at Barboursville Veterans Home. Change order number 1, closeout unused balance on CDO. Lists G4S Secure Solutions USA Incorporated at a different address from the original one we read, 233 McCorkle Avenue, STE 200, St. Albans, West Virginia. Invoice, all state agencies, various locations, as indicated by order, and shipped to State of West Virginia, various locations as indicated by order. And this lists something I've never heard of used in this context, an encumbrance certification. Now here it lists Region 2, Security Guard 2, a number of 5, job location WVVH 512 Water Street, Barboursville, West Virginia, from 2019 through 2020. This also lists a Security Guard 3 Supervisor, number 1, blah, blah, blah. Same job location. Now this lists West Virginia Veterans Home, September 1st, 2021, Lisa Nomar, Shared Services Manager, G4S Secure Solutions US Incorporated, 2, and from Morgan Sheets, Fiscal Procurement Supervisor, West Virginia Department of Veterans Assistance, /WV Veterans Home. The original encumbrance was for $180,960 with an open balance of $384.25. This is signed September 24th, 2021. This lists it as a C corporation that was has an effective date of 7/2/1969. Business purpose is administrative support, waste management, remediation services, administrative and support services, investigation and security services, security guards, patrol, armored cars, security systems, and locksmiths. Out of Kanawha, Florida. Local office address, the Wackenhut Corporation, 233 McCorkle Avenue, Suite 200, St. Albans, West Virginia, with a mailing address of 1395 University Boulevard, Jupiter, Florida. There, of course, you have the university again. Prentice Hall Corporation, 209 West Washington Street, Charleston, West Virginia, as notice of process address. And under the second section on director, it lists one other. Wonder who that one other is. Doing business as Correctional Food Service Management. Effective date 1997. G4S 2010. G4S USA 2010. G4S Wackenhut 2007. And just Wackenhut 2010. And then we have name changes of the Wackenhut Corporation from 2010. That appears to be all for that. This is copyrighted 2021 state of West Virginia. That's probably the first time I've ever seen that done. West Virginia copyrighted that information. Now, this document, a merger, lists the Wackenhut Corporation at 4200 Wackenhut Drive, number 100, Palm Beach Gardens, Florida, to be acquired by Group 4, right? G4S, right? Group 4 Falck, F-A-L-C-K, versus the previous signer for G4S Secure Solutions, Fulk, F-U-L-K. With a address, Polititorvet, DK 1780, Copenhagen, Denmark. This is dated May 3rd, 2002 at 9 a.m., where it was the vote was held at the Ritz-Carlton Palm Beach, 100 South Boulevard, Monopan, Florida. Now the next one is a prospectus summary listing we as our and the company refer to Wackenhut Corrections Corporation. These are senior notes due 2013, also referred to as the old notes. Here it stipulates we are a leading provider of government outsourced services specializing in the management of correctional detention and mental health facilities. We are the second largest operator of privatized correctional and detention facilities in the world, with operations located in the United States, Australia, New Zealand, and South Africa. Under our correctional facility management services contract, most of our government customers pay us on a per inmate per diem basis. Sounds like a monetary incentive to quote-unquote incarcerate, or rather unlawfully forfeit and deprive of life, liberty, or property without due process. The average length of our current customer relationship in 6 years, and of course the biggest thing here is that this is leveraging war and is treason. Since 1998, we have operated what we believe the only fully privatized state mental health facility in the U.S. at South Florida State Hospital. In December 2000, we completed the design and construction of a new 325-bed facility. This sounds like these people for a long time have been planning the devastation and demise of the general population under these security firms, and running them as the layered cover. I mean, it's a big deal to understand that the perspective of an intimidation of so-called law enforcement really are just subcontracted security guards who are incredibly incompetent and not expected to actually engage in a fight with anyone. It's no surprise they have to kill veterans by ambush. Pursue international growth opportunities. Surprise, surprise, it's the global cabal, as usual. Operate existing or new facilities on behalf of foreign governments. Operations in Australia, New Zealand, and South Africa, as mentioned before. Expand into new international markets. Few companies worldwide has the operational expertise, track record, and resources to compete for the management of large-scale privatized correction facilities. This is a big deal. These are outright overt enemy combatants, and they have nothing but bad intentions designed for us, and they are completely involved with the alleged government entities who are fully and completely 100% complicit and run out of the university mechanism. Now, this is an agreement from India. First party to this agreement is Sri Tarun Bhattacharya, General Secretary of DRBC Roy Engineering College, Durgapur. Registered office at Management House. Includes 1. DBC Roy Engineering College, DRBC Roy Engineering College Academy of Professional Courses, Jammu Road, Fulhor, Durgapur. DRBC Royal College of Pharmacy and Allied Health Services, and DRB Roy Polytechnic, Dr. Meghnad Sarani, Bidhannagar, Durgapur. I believe that's probably an area in India. The second party to this agreement is M/S Secret Eye Security Services, owned by a partnership firm registered under the Indian Partnership Act, bearing registration number blah blah blah, having its registered office at GT Road, Faridpur, PO Durgapur, blah blah blah. Now, as far as this contract goes specifically, it mentions similar things to that guideline that we saw before. It's dated the 1st of August 2020. Photo identity card. Every photo identity card issued by the agency under subsection 2 of section blah blah blah. The photo identity card shall convey a full image and color, full name of the private security guard or supervisor, name of the agency, and the identification number of the individual to whom the photo identity card is issued. That sounds like your typical so-called law enforcement badge. It's all for perception. It's all for appearance. It's not for anything else. It is, of course, for operations of treason and for those who are, in fact, instigating this stuff to hide behind layers so that they don't get held accountable. They don't get, as it were, justice done to them. And here it stipulates, essentially speaking, the uniform that we're all familiar with, an arm badge distinguishing the agency, shoulder or chest badge to indicate a position in the organization, whistle, shoes with eyelet and laces, headgear, clothes worn by the private security guard and supervisor while on duty shall be such that they do not hamper in his efficient performance. In particular, they will neither be too tight nor too loose to obstruct movement of bending or limbs. Every private security guard and supervisor will carry a notebook and a writing instrument with him. Every private security guard and supervisor, while on security duty, will wear and display photo identity card issued under blah blah blah. Matters relating to indiscipline by all or any staff of the contractor shall be the responsibility of the contractor. What a surprise. The contractor shall be required to regularly monitor the activities of all security guards employed by the firm and ensure adequate supervision over the personnel engaged during the 8-hour duty cycles allotted to such personnel by the contractor. And of course, the contractor shall be required to maintain a duty roster of staff deployed location-wise and have the same prominently displayed. Inadequate and improper services may attract commensurate penalties or deductions, and the college shall be free to cause such deductions and penalties. As per usual, control through financial, through threatened poverty, essentially. Fines and fees. All statutory liabilities, damages, compensation, etc. will be paid and borne by the contractor who agrees and undertakes to indemnify and keep indemnified the college against all claims arising out of negligence on the part of the contractor and or labor under its muster roll. This indemnification shall also extend to any claims preferred by any third party. What a surprise. Now, from the Companies House in the United Kingdom, dated 2018, we have Secret Eye Security Ltd., with the interesting listing of a Mr. Bartolomeu Jacinto Gracias, with an apparent nationality of Portuguese. Gracias, first of all, is Spanish for thank you. Jacinto and Bartolomeu are not, in fact, Portuguese. So that's interesting. But it gets more irritating. Evans Desir, that's EVENS, Desir, Investigation Services LLC, this is dated again 2018, same as the previous document, changes the name to Secret Eye Investigations and Security Services LLC, Evans Desir, and this is an article of amendment to Articles of Organization out of Florida with an address of 6900 Silver Star Road, Suite 206B, Orlando, Florida. Now, if you go to Bizipedia and look up Evans Desir, spelled EVENSDESIR, we find companies True Force Global and Security and Investigations LLC and Secret Eye Investigations and Security Services LLC and the creepy company of OK for Kids LLC. All of these are Florida-based. However, if we go to Ohio, we find a Desir Evans. First name Desir, DESIR, last name EVANS. at a location of 2372 Dewood Drive, Columbus, Ohio, for Untamed Security, LLC. Then we have an Evians, Eveans, L. Desier, 323 East 6th Avenue, Columbus, Ohio. Well, 3223, my bad. Devians Arbor Service, LLC, and this document is dated 2019. So isn't all of that interesting? But it gets, as per usual, much worse. Here we have ICE, FPS East, CG Region 2, Immigration and Customs Enforcement, Federal Protective Service, Office of Acquisition Management, 701 Market Street, Suite 400, Philadelphia, Pennsylvania. Discount terms as indicated on each call. Code ICE FPS East. Delivered to as indicated on each call. The contractor/offerer, Wackenhoot Services Incorporated, 7121 Fairway Drive, Suite 301, Palm Beach Gardens, Florida. Payment will be made by as indicated on each call. Issue date 2006, December 4th. GSA contract, guard services for Manhattan, Bronx, Westchester County, and Long Island. This blanket purchasing agreement for guard services in Manhattan, Bronx, Westchester County, and Long Island is established against GSA's schedule in accordance with RFQ number blah 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 and the Wackenhoot Services Incorporated. Proposal dated 14th of February 2007. Description of services lists federally owned and leased facilities protected by Federal Protective Service, FPS. Protected. Now, two acronyms of note are CO, Contracting Officer, and COTR, Contracting Officer's Technical Representative. This also lists Department of Homeland Security, DHS, Federal Protective Services, FPS, and lists that the contractor shall provide, there's that word shall, and that's very important that they stipulate shall in some sections, whereas other parts they might use the word may. FPS is the Department of Homeland Security and Immigration Customs Enforcement. And it states that FPS's mission is to provide a safe environment in which federal agencies conduct their business without fear of violence. Well, what is the purpose of a security guard? Right? For violence. So I don't know how you could have no fear of violence where that's just a ridiculous thing to write. And it's akin to the schools wanting to use force specifically against those who they don't want using force in order to teach them that the use of force is bad. So to teach someone you use force to teach someone that the use of force is bad. And they want somebody to act violently in order to ensure that people can conduct their business without fear of violence. It's ridiculous. And this lists visitors and federal employees perceive the security guards to be integral with the FPS mission. I don't think that could be stipulated more obvious. Customs and Border Protection, ICE, and every other entity associated with them are subcontracted security guards. That's what this is saying. The COTR and or CPM will inspect 10% of the security guard personnel records. Wow. The contractor will perform services in New York City, the Bronx, Westchester, and Rockland, Nassau, and Suffolk counties, New York. Contractor must possess all license, blah, blah, blah. The contractor bears the sole burden for ensuring that all legally required licenses and whatnot. Security guard and supervisor will have the authority to hold and detain individuals. Now, when I went through the border at Eagle Pass, the people that operated referred to the individuals of upper level as supervisors. And again, I reference this document. Armed guards must carry their firearm license permits on their person while on duty. Of course, not just anybody can ensure they do that. The CO and COTR and all other authorized government personnel shall have the express authority to examine these documents upon request. So nobody else can. You can't go to these places and demand to see their documentation. They'll laugh in your face. Illegal or undocumented aliens will not be employed by the contractor, and this will be expressly incorporated into any and all subcontract or subordinate agreements. Of course, there's really no penalties for the doing of this. It's quite ridiculous. But as long as they list it everywhere, then that's fine. And of course, their alleged requirements are to be a citizen of the United States, have a Social Security card approved by the Social Security Administration, at the request of the COTR and CO, may waive the minimum age requirement where the applicant meets all other minimum requirements and is legally eligible to perform the required duties. Okay. Speak English fluently, read and comprehend written English, and compose coherent written reports in English. Bilingual security guards may be an asset to the contractor, but in no circumstances should the contractor permit a security guard who does not have good command of the English language to work. Now, I can vouch for the fact that this particular section is not followed at all, because one of the supervisors, the ridiculous waste of space and complete human garbage, if she was even human, Tapia, Supervisor Tapia, could not speak coherent English at all. 3 years of security experience within the past 5 years, or an associate's degree in related field and at least 1 year of experience. Those don't seem that steep, but the major talent pool is from overseas, as when I went through traveled through Mexico and Ecuador, there are security guards absolutely everywhere. That's where the talent pool comes from. This lists an FPS certification card and contractor provided quality control plan. Resumes for all employees appointed to serve as quality control monitors. Under no circumstances shall individual appointed as quality control monitors serve as uniformed employees working under this task order. That's an interesting distinction. The CO has the authority to negotiate and take an equitable adjustment from the contractor's monthly payment for quality control not provided. Repeated offenses can result in termination for default. Uniformed or undercover surveillance by FPS staff. So that's what they would normally call a probe. The contractor may be financially liable for accepting or implementing changes by anyone other than the CO. Therefore, the contractor shall be responsible for verifying with the CO whether any requested changes should be provided pending issuance of task order modification. Security guards must be thoroughly familiar with the post orders at all posts where they are assigned to work. Under no circumstances should any security guard neglect his or her assigned duties in order to familiarize himself with post orders. That's a pretty strange and ridiculous thing to include. Now, here they list out the duties of border control, ICE, and all of these other fictitious law enforcement entities. Access control, package screening, personnel screening, visitor processing. That's a big one. I did not know that when I went through, I was operating under the assumption that the border was operated by quote-unquote federal agents, and they had duty, responsibility, bonds, and oaths and things like that. I did not know that I was a visitor and they were security guards, and when my wife, myself, and my daughter, of which they were most definitely trafficking children through there, the security guards wearing USCIS clothing were definitely trafficking children, doing other heinous activity. Well, they listed the fact that we needed to be processed. And hence here you have the stipulation visitor processing and vehicle inspection. Now here it lists security guards shall perform package inspection when and as directed by the security guard post assignment record, post orders, or as directed by the COTR in the event of an emergency or an elevated security posture. These inspections may be conducted using automated technology or by manual visual surveillance and include but are not limited to inspection of packages, briefcases, purses, canisters, bags, valises, and other containers in the possession of visitors, employees, and other persons arriving on, working at, visiting, or departing from the facility. Admittance will be denied to those persons refusing to submit to a voluntary inspection, except for those persons exempted by specific government directive. Boy, isn't this stuff completely eye-opening? Each security guard shall be familiar with each tenant agency's name and the locations within the facility of the most commonly sought-after offices or locations. Security guards shall not be permitted to remove the keys and other access control devices from the facility premises unless specifically authorized by the COTR. Keys or access control devices that are missing, lost, unusable, and or stolen shall be immediately reported to the FPS Mega Center, the COTR, and the security guard supervisor as soon as the security guard detects loss of the problem. Environmental intrusion detection systems, alarm sounds, immediately record the incident. Security guards shall not disengage, shut off, remove, reposition, obstruct, or in any way interfere with government video surveillance cameras / systems. FPS Mega Center is an important name to note here. Security guards are not janitors. Building maintenance staff, delivery persons, receiving officials, or mechanics will not be required or expected to provide any building system services except the very basic functions as required in the post orders. No, they get the unlawfully and involuntarily detained visitors to do that work for them for free. Physical security, law, and order. Security guards shall maintain physical security, law, and order as prescribed by statute, regulation, and post orders. Security guards are responsible for detecting, delaying, detaining, and or apprehending persons attempting to gain unauthorized access to government property or otherwise violating laws, rules, and regulations. And that right there is their unlawful leveraging against visitors, whether you're a U.S. citizen or otherwise, through the so-called ports of entry. While on duty, security guards shall verbally report threatening circumstances of potentially threatening activities they observe to the FPS Mega Center and, when possible, to the COTR. Whenever possible, security guards are encouraged to report a serious or potentially serious problem before responding so that they may receive all necessary backup and support to lessen or eliminate the potential threat. They shall, this is for testifying, unless otherwise required by the COTR contract task order, employees who are scheduled to testify on behalf of the government shall appear for court testimony in full uniform but without weapons or firearms. So basically, if these people appear in their court, they're going to be wearing their USCIS Customs and Border Protection uniforms, and no one will be the wiser that they're subcontracted security guards. Civil disturbances. Security guards will be required to perform other such functions as may be necessary in the event of situations or occurrences such as civil disturbances, attempts to commit espionage, sabotage, or other criminal acts adversely affecting the security and or safety of the government, its employees' property, and the general public lawfully in buildings or on the grounds under the control of the government. This stuff is quite ridiculous. This lists an occupant emergency plan. This is definitely the constitutional definition of treason, absolutely, without a doubt. This is leveraging war on behalf of foreign elements. Primary security response. In some situations, security guards may be required to act independently as the primary security response until a law enforcement assistant arrives. And of course, the law enforcement, as we read earlier, are also subcontracted security guards with the same companies. Erasers, obliterations, superimposed or double entries of any type on any one line are unacceptable and will not be credited for payment purposes. And here we get, of course, into the financial control mechanisms. If errors in signatures, times, post numbers, or duty status are made on the security guard duty roster, the employee should draw a single line through the entire line on which such mistakes appear. The next line immediately below or following on subsequent sheets will be used to record all information in the correct manner. The contractor must attach a detailed memorandum of explanation to each security guard duty register containing erroneous entries describing all mistakes made with the applicable valid lines of information and for reporting the reasons for those mistakes. Payment of invoices is based on these procedures. So all their control, as usual, is based off of doling out money that they stole from someone else, and then with strings attached to it is basically do what we say, or we're going to pull funding and we control the money because that's how it goes. Services required manager, key personnel. The contractor shall propose, identify, and provide to the government an experienced manager, CM, who shall have the complete authority to act for the contractor during the term of the task order. The duties of the CM shall not, under any circumstances, be performed by uniformed employees performing productive or supervisory hours under the term of the task order or any other guard task order administered by the FBS. The CM shall have the authority to accept notices of deductions, inspection reports, and all correspondence on behalf of the contractor. The CM will have the overall responsibility for implementing, monitoring, and upgrading the contractor's quality control plan and is responsible for ensuring that the contractor's workforce complies at all times with the task order requirements. The CM must completely understand the operational requirements of this task order, including the CM is a salaried managerial position, not specifically required in the line items identified in this SOW. Therefore, the contractor shall factor all costs associated with providing a CM into their offering prices, as they will not be itemized or paid separate by the government. The terms area supervisor, on-site supervisor, and supervisor are interchangeable and mean a person who has authority to act for the contractor on a day-to-day basis at the worksite. And again, like I said, the individuals in command at the Eagle Pass border post crossing where I crossed from Mexico to the United States are called supervisors. The CO and COTR have the right to request the replacement of a supervisor that does not meet performance standard expectations. All security guards shall be in uniform and ready to begin work promptly at the start of their shift and shall remain on the job and in full uniform until the end of their full tour of duty. Specific hours of supervision will not be required under this task order. Instead, the contractor shall be responsible for providing a level of supervision sufficient to ensure effective performance of the productive security guards over the course of this task order, as agreed to by the government as part of the contractor's technical proposal and incorporated in the task order upon award. In the event that the government determines that the supervision provided by the contractor is insufficient to effectively manage the security guards, the government and contractor shall meet to discuss the contractor's supervision plan and ways in which the contractor's performance can be improved. The contractor shall be required to maintain at all times an on-call reserve force. This reserve force shall be a sufficient size to provide the amount of temporary or emergency staffing services in the event of natural disaster, civil disturbance, and or other unanticipated event. Additionally, the reserve force shall be of sufficient size to enable the contractor to provide post coverage in the event of scheduled or unscheduled security guard absences. I mean, this stuff could not be more clear. They are leveraging warfare against all of us. The reserve force must be equivalent to at least 10% of the existing security guard force. These could not be called anything other than enemy mercenary elements. The limitation on hours may be verbally waived by the COTR in emergencies which are beyond the control of the contractor. Blah, blah, blah. 12-hour on-duty limitation. Contractor bears the entire responsibility for scheduling and coordinating with FPS for the government, provided training courses, written examinations, weapons qualifications, first aid, CPR, AED certifications. Any designated representative of the CO shall have the express authority to observe any training session without any advance notice. Provide to the contractor one copy of the security guard information manual, and they are responsible for photocopying at no cost to the government. And this lists a basic training course. Now, of course, anybody in the military goes to quote-unquote basic training. The CO shall have the sole discretion to accept or deny any proposed exemptions. FPS firearms qualification standards listed here. Federal Law Enforcement Training Center Exhibit A4E. Exhibit 4E. There's a lot of work with this number 4. They must requalify in the practical pistol course. No additional cost to the government. Upon the employee's completion of the basic training and favorable reemployment suitability, the contractor must schedule a government-administered written examination with FPS that will test their employee's familiarity with and understanding of the information contained in the SGIM after the employee's productive and supervisory successfully complete and the applicable course. The test has 50 multiple-choice questions. All the questions on the test are taken verbatim from the SGIM. Passing score for the examination is 70%. If an employee does not pass the examination in the first attempt, he will be given one additional attempt within 90 days from the date of the first failed attempt to pass the written examination. And it goes on with more nonsense about that. No waivers will be granted regarding the testing policies and procedures stated above. Now here's an interesting designation here, or specification. The government requires that each employee who receives firearms training shall fire at least 500 rounds of ammunition during the course of range training. I have no idea why somebody would specify something like that. Very odd. And they qualify with a distance of at least 25 yards. This is a joke. These people are fodder. They are not worth their entire capacity is based off of people's fear developed through movies and television and the university system and attorneys and falsehoods. They are not effective fighters. They're complete garbage. I mean, in the Marine Corps, you tend to joke about the Army and the Air Force for minimum qualifications of 75 yards, considering we start at 100. This isn't even that. These people only qualify with a pistol at 25 yards. They are a joke. There's no reason to take them seriously. And that's a big and important thing here, because when regular people come to that realization and that understanding that sheriffs specifically are incapable, well, there goes their ability to evict people. If most individuals understand that these people only qualify with pistols at 25 yards, then they lose all capacity of respect, and they lose their ability to enforce anything. And in fact, it's the other way. If they attempt to enforce something, they will die because they are not capable. They cannot engage in a fight. They're complete garbage, and it's intended that way. The people hiring them want them to take the fall for this treason. Most of the people doing it are subcontracted security guards from foreign countries, and they have no idea what they're doing. Firearms qualifications that are not witnessed by an FPS firearms trained employee will not be deemed acceptable for the purposes of this task order. The contractor must provide the necessary weapons and ammunition. For training and qualifications, the contractor should provide a list of serial numbers to the COTR, or if contractor provided firearms to be used for qualifications 48 hours prior to scheduled qualification, blah, blah, blah. The contractor shall certify in writing that the employee possessing the temperament, maturity, and judgment to make responsible and correct use of force decisions under pressure. Now, the biggest thing here is that this is levying war. It is the constitutional definition of treason, and regardless of that stupid bullcrap provision that they put in there, that treason shall be under the punishment for treason shall be determined by Congress. There is no Congress, and that was revised in there, considering it conflicts with the section in the Constitution about jury decisions are always final. Well, the fact is that for a long time, treason has been established that the punishment is death. All of these people are engaging in constitutional definition of treason. They warrant death, every single one of them. The government requires that each CPR/AED course must provide practical training dummies on resuscitation techniques based on Red Cross or American Heart Association techniques. Yeah, what a surprise there. And I'm sure more people die by natural causes. In certain cases, the contractor's employees will receive special training and will be given by the tenant agency or by the FPS. The number of training hours and the posts to which the special requirements apply will be provided when the requirement arises. The contractor will be required to schedule the training to provide remuneration to all security guards for off-duty training at the regular hourly rate salary and blah, blah, blah. FPS training instructor shall compile a list of all employees who have an unexcused absence for each day of training. The list will be forwarded to the CEO, and the costs associated with the security guard's failure to attend will be deducted from the contractor's next monthly payment. So as per usual, control via financial mechanisms, which is something you would do if you're a foreign entity who cannot actually directly control something, so you use the financial leash as your mechanism. And of course, these people print the stupid US dollar crap. They hypothecate, they take out loans, they purchase things and then foot the purchaser with the loan. They engage in rampant fraud. They do whatever they want, and the entire motive is to cause damage and destruction in an area that they don't reside, so they don't directly feel the effects of it. The contractor, not the government, is responsible for complying with all provisions of the Americans with Disabilities Act, so that just basically means they don't have to. The contractor shall require all of its employees who are prospective FPS task order guards to undergo pre-employment medical physical examination. The contractor is sure that all of its uniformed employees meet the medical blah blah blah. Applicants must be able to distinguish basic peripheral vision and must not be colorblind. Applicants must be able to hear the whispered voice at 15 feet with each ear. I don't know why someone specified that. That's really weird. How do you determine that? You know, there's no real way to determine that in a effective manner, because you're going to have different variation in environment and all kinds of things. You know, you could be doing it in a hospital that's next to a highway. It's just ridiculous. Individuals must have a healthy gastrointestinal tract. That's weird to list that. Any disease or condition that interferes with gastrointestinal function and the individual's safe and efficient job performance is a disqualifying factor. An ulcer active within the past year may also be a disqualifying factor. That's just weird. So this is just weird stuff. Really, really weird. Medication. The individual's use of medication such as narcotics, sedative, hypnotics, barbiturates, amphetamines, or any drug with the potential or for addiction that is taken for extended periods of time, e.g. beyond 10 days, or is prescribed by a persistent or recurring underlying condition is a disqualifying factor. Physical demands, subduing violent or potentially violent individuals. Now, why would somebody be potentially violent or be violent against these people? Well, it's certainly because they're nice, just good, honorable, above reproach individuals simply because they wear a uniform and have a title. That must be why. Joined together, number 6 and 7, wearing of body armor and apply handcuffs. Physically subdue or engage in confrontation. Physically control crowds or bystanders. Pursue suspects on foot and subdue combative persons after running in pursuit. Contractor, not government, is responsible for complying with the provisions of the, I already read that before. Lists frequent contact with the general public, law enforcement, and the dispatch center, requiring the ability to speak clearly and distinctly and remain calm in stressful situations. Confrontations with angry, distraught, disturbed, or violent persons. It's so obvious. They're expecting this. This is their intention. They want to make people violent, disturbed, or whatnot, and they want to, of course, say that it's that person's fault. They expect it. They want it to happen a lot because they are enemy combatants. This is the purpose. Ability to remain on post for up to 4 consecutive hours without eating, drinking, or relieving bladder / bowels. Now, what is the purpose of all this exactly? Why so much effort to manufacture, under the color of law, a security force in which numbers and ignorance is the important element? Well, this brings us to the Ohio State University's Emergency Operations and Evacuation Plan from December 2001. That's an interesting year. EOEP. It lists a location for the Ohio State University Police Department, most likely subcontracted security guards like all the rest of these. Blankenship Hall at 901 Woody Hayes Drive. It lists an environmental health and safety with a purpose of support for hazardous material spills and releases. That sounds like your chemtrail stuff. Now, this lists security services for select university facilities. Well, that is an interesting name, considering what we just read. Not including maintenance or repair. Well, issues involving alarm systems, not including maintenance or repair. Sounds like espionage. And this also lists the Division of University Public Safety at the same address as the so-called Ohio State University Police Department, Blankenship Hall, 901 Woody Hayes Drive. Also with the separate Office of Assistant Vice President for Public Safety. For University Security Services, they are responsible for the maintenance of the university's overall emergency response and disaster planning efforts. That sounds like they're planning disasters. Now, interestingly, they have this bomb threat explosive device data card, which lists under number 8 and 9, what is your address and what is your name? These people see this stuff as a joke. Who would write that? Who would call in a bomb threat and give an address and a name? And who would bother asking something like that? Of course they're going to lie. Unless, of course, it's Jack Sparrow. Now, screening packages and letters. Suspect letters packages are handwritten addresses. Handwritten addresses is listed here for a suspect letter or package. Restrictive markings such as confidential or personal. Foreign writing. And the source of the letter. That's just about all mail. And I like that they particularly list confidential. Those are packages that they want to restrict, open, and read. I honestly don't know how these people, the nature of these organizations could be more clear. They are according to themselves, their own state, their own government. They do what they want. They don't have to abide by anything. And they do it through these security forces that operate under the color of any agency, and as it says before, you don't know, it's not perceived, they are perceived at least, to be an integral component. Now, one of the things that they really want to protect in this regard is from intellectual property. Ownership of inventions subject to terms of Section 6. All rights, title, interest, inventions are the sole property of the university. Every student hereby grants the university the following licenses. A non-exclusive, perpetual, worldwide, royalty-free license to use any inventions created as part of a course or university degree program for administrative purposes. That is the exact wording of the copyright section on that one contract that we just read. A non-exclusive, perpetual, worldwide, royalty-free license to any use of any inventions that the student owns that were developed by the student with more than significant use of university resources, not as part of a course or university degree program. They are claiming ownership over all intellectual property of any student. Ownership of copyrighted materials, all copyrights in instructional works, scholarly works, and artistic works whose creators are faculty members except for software remain within their creators. So here you see a stipulation that the students are treated as a body for free labor and exploitation. They take everything from them and give nothing. The faculty are not treated the same way. So every time you get these little airhead, brain-dead faculty members and tenured PhD morons coming out saying that they're being exploited, they're attempting to cash in on the social credit of what they are actively doing to students, willfully and knowledgeably. There is no member of academia, just about, who is not complicit in these crimes. Subject to the exceptions set below, copyrighted materials created by staff within the scope of their employment is owned by the university. So there is that stipulation. The principal investigators of the research project for which TAF proceeds are to be received, that will receive for the purpose of Office of Research and Distribution, blah, blah, blah. Share of these proceeds, such a distribution plan should be created by the commencement of the research project. And this just kind of has to do with their financial leash that they always use. This is an interesting section here. Notwithstanding the other provisions of this policy for licensed plant varieties, what is a licensed plant variety? That's really weird. Proceeds will be distributed pursuant to Special Circular 178-01 entitled OSU OARDC plant germplasm release guidelines and practices. Now, the TCO is the Technical Commercial or Technology Commerce Office, I believe. Something like it's Technology Commercialization Office. Intellectual Property Evaluation, Protection, and Dissemination. TCO will strive to reasonably advance the well-being of the people of Ohio and the global community. Maximizing the commercial value of university IP. All creators who are assigned the university IP pursuant to subsection blah 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 will grant the university its perpetual worldwide non-exclusive royalty-free license limited non-commercial use of such intellectual property. Okay, so they can issue to someone so-called university intellectual property and just list it as that, and then that forms the evidence for it being university intellectual property. It's more just ways to arbitrarily steal people's intellectual property. University employees engaged in external consulting work or businesses and those charged with approving such activities are responsible for ensuring that agreements with external entities do not violate or conflict with the policy or any other university policy, including the faculty-paid external consulting policy and the conflict of interest and work outside the university policy. Now, the IPPC is the Intellectual Property, Patents, and Copyrights Committee. The claimant will submit the complaint in writing to the chair of the IPPC, who will determine whether the claimant has made a reasonable effort to resolve the dispute informally and whether the substance of the dispute appears to be within the scope of the IPCC's review authority under the policy. This is just like everything else that I have discovered in reference to universities. The only way to hold them accountable in this little corrupt control system that we all live under is to submit to the people causing the abuses for their determination about whether or not they are the ones causing the abuses, or whether it's not abuse at all. It's amazing. IPPC will publish its reports after removing certain information as needed to address reasonable privacy or secrecy concerns and the decisions of the senior vice president of the business and finance and or the provost. The publication will be reasonably accessible to the university community. These reports and decisions will guide future actions and decisions by the TCO and IPPC. And if that's not enough, all revisions to this policy must be approved by the Faculty Council and the University Senate. This stuff is just bonkers. Now, this is an agreement dated the 2nd of February 2012 between the Ohio State University, the Ohio State University Alumni Association Incorporated, and the Huntington National Bank. It lists Huntington and are parties to the Ohio Stadium Scoreboard Sponsorship Agreement ending August 31st, 2016, agreement for the Schottenstein Center June 1st, 2008 to June 30th, 2016, and the trademark license agreement. This is lists the expansion, include the provision of banking and other services by the Huntington to the Ohio State. Now it's interesting when it lists out Ohio State in all caps. Not Ohio State University, just Ohio State. It is the official consumer bank of Ohio State. The parties specifically agree that insurance products and services are excluded from the definition of consumer financial services for the purpose of this agreement. It lists a full-service on-campus bank, prominent location in the new medical center building. University District Investment and Loan Commitment. Huntington commits to make $75 million available in loans and $25 million for investments for use in revitalizing the university district. This is, of course, how they take over land. Subject to Huntington's normal underwriting and credit policies, procedures, and agreements, rules, and regulations, the University District is comprised of the 4 districts shown on the map attached as Exhibit C. Huntington further commits to provide a banker dedicated to the University District to focus on the consumer and commercial financial services of the area. And of course, naturally, there is no specification for collateral. It is an unsecured, massive loan That doesn't need to be backed by anything, and that is yet another piece of evidence to show that these individuals can print money at will. And the banks, of course, are involved. Marketing exclusivity subject to, this is a monopoly, by the way, subject to the rights granted pursuant to the pre-existing agreements as set forth in Exhibit A and defined in Section 4 below. Again with this number 4. Ohio State grants to Huntington marketing exclusivity within the consumer financial services category at facilities and to organizations that are under the control or authority of Ohio State or affiliates that have agreed to be bound by this agreement. Rights include all marketing and promotional rights related to Ohio State and its individual schools, including but not limited to those more specifically set forth on Schedule 1.7. The marketing exclusivity granted in this agreement to Huntington shall serve to prohibit Ohio State from contracting with any other consumer financial services entity, except as expressly permitted herein. Notwithstanding the foregoing, Huntington agrees to permit short-term, limited, and non-material advertising or sponsorship opportunities for other consumer financial services entities, and blah, blah, blah. That's essentially akin to the monopoly afforded to the East India Trading Company on tea by the Board of Trade. That was a big deal prior to 1775. This is the same stuff. But with the new twist that this number 4 and G4 relates to the g-quadruplex concept in the regulation of the DNA of an organism. And in this context, we are understanding the juridical organistic entity that they are creating. And not only that, in the future, they intend to unleash a proliferation of uniformed subcontracted security guards to leverage warfare against the people, being the nation, and the land, being the country. Thank you.